Exactly. Good afternoon. Good afternoon, everyone. It is so wonderful to have you here. For those of you that do not know me, my name is Rosa Celorio. I actually serve as Associate Dean for International and Comparative Legal Studies at this law school. Many of you are my students. I know you, at this law school, so it's absolutely wonderful to see so many students that have come, to see Professor Alma Luz Beltran y Puga talk a little bit about her fantastic work. But first, I want to start by talking a little bit as to why we have a Woman in International Law speaker series. We actually created the speaker series in the ICL program a few years ago, and the idea is to showcase important experts, decision makers, leaders, policy makers that are really making strides in the area of international law. Unfortunately, women in international law don't necessarily get the necessary showcase. They don't necessarily have the platforms or the spaces to be able to share their work. So we wanted to make sure that our program at the law school supported creating spaces, for wonderful experts. And I have to say, I am so incredibly honored that Professor Alma Luz Beltrán y Puga is here. I'm about to introduce her, and she has a really long bio, so brace yourselves. This is gonna take some time because she's done a lot of things. But one thing more on a personal note that I can tell you is that I've actually known Professor Beltrán y Puga for a number of decades now. I know, it sounds like we're so old.
Don't tell the number. Just vague.
Exactly.
Decades.
Exactly, decades. At this point, we're middle-aged right now. But one thing that for me has been a great satisfaction is to be able to see Professor Beltrán y Puga in many stages in her career, And it's incredible to have seen her, not only as an attorney for the Human Rights Commission, but then also as this major women's rights activist for HIRA in Mexico, and then as this academic, and she has quickly risen to be, in my view, the most well-known and groundbreaking academic in Latin America on gender and law issues, And I'm very honored, to be able, not only to be her collaborator, but also to co-edit publications like the one that she's gonna be talking about today. So I just wanted to start by saying that. But I want to tell you a little bit more about her. She's currently a professor of law at Iberoamericana University in Mexico City. She's affiliated there with the Center for Critical Studies on Gender and Feminism. She holds a PhD in law from the University of Los Andes in Colombia and a Master's of Laws from Columbia University, where she was a Human Rights Fellow and a Fulbright Scholar. Her research focuses on gender, law, and social movements in Latin America, particularly on the legal strategies of feminist movements in Colombia and Mexico to promote reproductive rights. Previously, she was also a professor of law at the University of Rosario in Colombia, where she co-founded the Gender and Law Group. She was also, from 2022 to 2023, an affiliated researcher at the Petrie Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School, and has been a consultant to advance gender protocols in the judiciary in the Dominican Republic and the Latin America region. In 2009, she received the Rómulo Gallegos Fellowship to advance women's rights in the Inter-American Commission on Human Rights. She's also a member and also one of the leaders of the Red Alas in Latin America, which is a network of legal scholars working to advance gender and sexuality in legal research and education. She also co-edited, in my view, she was the leader of this book. She's going to talk about that in a second, Building Bridges, Contemporary Perspectives on Gender, Sexuality, and International Human Rights Law, which was recently published by the University of El Rosario and Red Alas as an open access source, so you can access it in the internet, which is fabulous. You don't have to pay for the book, which we love. It's freely accessible. She also has X accounts. She's very actively involved in social media if you want to follow her work as well, And I have to say, before I even start asking her questions, I actually want to thank as well the 35 authors, that were part of this publication. It has been a journey, for us to co-edit this publication. You will see it's a combination of academics, but also practitioners in the area of gender and the law. And one thing that gives me a lot of pride is that two of the authors are actually alums of this law school, Laura Calle and Rebecca Ego, and also Chelsea Ullman from the Global Women's Institute also authored a piece as well. Okay, we're always encouraging scholarship from our students as well, so it's wonderful to see our students also publishing in this capacity. I also want to extend a big shout out and thank you so much to Professor Leah Calabro, to Jinxie Dai. They have such a critical role in the work of the International Comparative Law Program and all of the events that we're hosting as well, this semester. So thank you so much to both of you. Okay, without further ado, I actually have a few questions for Professor Beltran y Puga, if I may,
But let me thank you first. Well, it's so awesome to be back here with Dean Celorio. And it's been 10 years since I lived here. So there's 1 decade coming there. I love DC. I love to be here with you. I've also known Rosa for so many years now, and I'm very grateful that we can actually meet in person, not in a virtual scene as we began the book. Right, we began the book in the pandemic, and it was everything on Zoom. So I would also like to acknowledge the enormous pleasure of being sitting next to each other after that humanitarian and public health crisis. So I'm also very grateful for you to bring me here to a city I love, to very fond memories of our work together in the Inter-American Human Rights Commission, where I met Dean Celorio. And of course, she speaks like that of me because she is my mentor. So obviously, friendship and colleague, and you have so much luck to have her as a dean. And thank you again, Rosa, for having me here.
Thank you so much for being here. And we're all very curious, actually, about that trajectory and all of that work that you have been doing for a few decades. And one of the biggest questions in this series, that we do, once a year is how our speakers got to where they are today, right? And you have this wonderful, very rich, very intricate career as a scholar and activist. A lot of it has been devoted, to women's rights and gender issues, but also family law issues. You have worked also in academia, but also in civil society. When you went to law school, and when you went to graduate school, did you know that this is what you wanted to do?
Well, 2 decades ago. 2 decades ago, when I entered law school, and I thought, this is a career where you should be devoted to social justice, but also I want to be, in a way, sort of diplomat. No? I entered law school with an idea of international relations, of thinking in a global scale, but also a law school can be a difficult and tough place, and you can also be very bored with certain courses, right? Tell yes. I'm all the only bored with procedural stuff. So at some point I thought, is this the career I want to be in, with all these legal processes, and maybe in Mexico we are trying to change how legal education is being conveyed. But when I was in the law school, it was a very rigid and memoristical, the way of approaching law. And what really turned me on into law was feminism, and was my entrance to the women's rights movement. And as I was reflecting on why did I stay being a lawyer, but because at some point You can say, well, shall I stay or should I go? No, and I stayed because when I had my first interview with a very, well-known feminist movement activist, Marta Lamas, and she's quite old now. But don't tell her, right? Experienced is the good question, is the good name. So she was a very well-known activist, and this is the time where there was no Google, so you couldn't really Google who she was. She was in the news. Of course, I knew who she was, but you came to the places with a more blind eye, And when I entered the office and I saw this great woman, of gray hair with these hipster glasses, and she tells me, so you are my first job interview, right? So you want the post for a lawyer. So there was no lawyers in the NGO. Yeah, no, and I was really naive about my positions about abortion. So she starts to inquire me as to reproductive rights and stuff. And then she tells me, well, this is not really a job. This is a cause. This is entering, this is not a job from 8 to 5. So as I reflect now, this is how I entered the women's rights movement, right? And I became aware with time of what it means to be a cause lawyer. A cause lawyer is someone that advocates for a cause or for a social cause or for a client. But imagine, law for me means to advocate, to have a passion for something that you care so much, that you devote more than your time, right? You devote your imagination. You devote how you want to change, the legal order, or how you put the legal order to work for that cause. And as I really didn't have, a lot of knowledge on feminism or on social theory in general, but advocating as a young lawyer for the decriminalization of abortion in a Catholic country poses a lot of obstacles, and you began to reflect on why is this legislator telling me this stuff? How can I convince him or her that this is a cause she or he should regulate differently from what the criminal code says? So I started in a young, very young situation at a very early age to try to communicate law differently, because not everyone understands technicisms. So cause lawyering is also a way to communicate law differently to people, because social justice is not a thing that it's abstract and it's supposed to be on books. It's supposed to be a transformation on the streets and on the Congress. And how shall we think that law should adapt and change so that people can have a better life? And so this is why I actually became in love with law, because I thought it was useful. And when you see the utility or the usefulness of something, you keep in that track, right? Because if I thought, well, this is not useful, because we actually did decriminalize abortion in the first 12 weeks in 2007, and I thought, you can accomplish things, and when we saw that the law was not only on paper, but that there were public health clinics opening for women that otherwise wouldn't be, accessing that public service, I felt a great joy. I felt that, because we always see, women's rights and the backlash, and we'll talk about the backlash, because there is a backlash. But then you also have to say, we did it as a collective, because of course we were working with a really organized network of feminist organizations, and we also had a communication strategy and dealing with the doctors and conscientious objection, and a lot of stuff was going on. But when that law passed, I felt everything is possible. Everything is possible. If you can pass this law in a Catholic country where it seemed really, really, really difficult, then we must have been doing something good.
It's interesting that you just mentioned the passage of the law. Because one issue that we're always discussing in our classes, especially international law, right? A lot of the students here are taking either international law or are specializing in international law or are taking women's rights courses or human rights courses. And a constant question is, where are the positive results? Is there compliance? Is there enforcement? What can you really achieve with this? And one connected question for you. You've been working in gender issues and in feminism for a few decades now, right? You've seen a bit of an evolution on this as well, And you as an advocate, as a professor, how do you see feminism now in comparison to how it was when you started, And where do you see opportunities?
Well, that's a huge question, because it's a historical question. And the questions regarding history now trap me a lot, because this is what I did in the PhD. I tried to solve a historical question regarding not abortion but divorce, which is another topic. And so I feel, and now that I was arriving and you were telling me, what color were you wearing, right? So I wear this jacket because this is the jacket of the green wave. It's green is the color of life, and the green wave, and these green handkerchiefs. I don't know if you know why they are green, but they are based on the claim of the grandmothers of Plaza de Mayo in Argentina, who fought to reach out to the disappeared sons and grandsons of the dictatorship of the 80s. And they were hanging these white handkerchiefs, right, in the sign of peace. So for the feminist movement now, we are doing the green handkerchiefs in the memory of those abuelas and of those grandmothers that had an idea of peace. But also, now we are wearing a different color because this is the color of life. And the feminist movement wants to resignify what reproductive rights means in terms of you are not ending with a life, but protecting one or both, because we believe that life is not only the right to be born, but the right to have a quality of life. And so I feel like in terms of the historical path of the feminist movement, the feminist movement now has achieved a tremendous, resonance in Latin America, because we have symbols that unite us across borders. And we have similar problems that we have been in a transnational conversation with. So I am Mexican, but I have friends in Argentina, I have friends in Colombia, I have friends here in the US, and we deal with similar problems and we strategize them. And so I think in this era, because this has always been the same with the feminist movement, the feminist movement, if you see a historical on why it was born out of discrimination and inequality, which we continue to fight for against it, but also in what social movements theory knows as the repertoires of action or collective action, how we strategically organize to change and do social transformation. This has been a common issue in the feminist movement. And before we had emails and the chat and digital protest and stuff, well, we did letters, right? We wrote letters. So it's marvelous if you go to an archive and you search in the newspapers and how people before communicating, before did the communication skill, they drafted letters, they drafted, how do you say, memos, right? Even, do you remember the fax? You don't, probably. But there was a machine called fax that was more rapidly communicating than the telegraph. So I'm speaking of old ways, but in my conclusion is we have done the same. So in that sense, we still do international communication and networking, and what may be different is the discourse, is the narrative. So, for example, in the case of reproductive rights, it started in the 80s as voluntary motherhood. So Marta Lamas, who is an anthropologist, spoke not about reproductive rights or reproductive choice, but a voluntary motherhood. And from that, it's been studied, right, in the academia, how the UN and international law discourses came and were being, very important to the Hillary Clinton quote of women's rights are human rights in the 90s, where there was being the celebration of treaties, and we were thinking, that women or women's rights or women's necessities needed specific treaties to be ensured and guaranteed at the international level. At this point, in that quote of women's rights are human rights, is an interest, of trying to build a specific claim into the universal legal order, because international law is a dream of global governance. And so how do you put gender or race or class into the dream of global governance? It's a really tough question. So, but I think that this has been a feminist movement interest on how to put those difficult questions in the international and global governance project that has made this movement so rich and so inspiring in a way.
It's so interesting that you mention global governance and the connection with gender issues, because a lot of what we also discuss in this law school is how women, and LGBTIQ plus groups, have been largely absent, from a lot of the developments and advances, and how we have progressed, but we're definitely still in a moment, where we still have a lot to do, a lot of critical thinking to do. And I think that connects me or takes me to our publication, because our publication does discuss some of those voids, right? Where we should be heading with international law in these topics, So I have a few questions about the publication for you. Okay. And by the way, we do have a fax machine at the law school. It's in the Dean Suite. None of us know how to use it, but we do have one. Okay. So tell us a little bit about why did you come up with the idea of this publication?
Rosa, because of you. I think we both came up with that idea. I don't want to claim I'm in this with you. Okay. This is our baby project. This is our little hije. So no, when I was working as a professor in this Colombian university, the dean of the law school approached me and told me, we should do a conference. We should do a conference on gender and sexuality. She didn't put that in those terms, but for me, it was a conference on gender and sexuality. International, to refresh the conversation of international law. And at first, I think she was thinking of Colombian professors. Then I thought, that doesn't make sense. An international conference, no, on gender and sexuality with Colombian professors. Like it doesn't, I mean, it's not that Colombia has not, a rich academia and a strong legal feminist academia. This is why I went there to study the PhD, but it's not the only one. So to answer your question, I thought this is a transnational book because we have never had these conversations in a local setup, or at least me. I have always tried to have these conversations with my Argentinian friend, my US friends, So I decided that it would be an open call for papers. And I told Rosa, I didn't felt I could do this alone because it's better to do things with your friends, with your peers, with someone, with your mentor, with someone you admire. So I thought, the perfect person, the partner in crime I need is Dean Celorio. Do you agree with me? Of course you agree with me. So I immediately thought, this is a thing I should do with Rosa. I should because you were now the dean of the comparative law program, rah, and I thought this is an international conversation. Why keep it local? Why do it small if you can do it big? This has always been my question, right? If you can think big, why think small? So this is why are we here, thinking big? And the book. So we set this call for papers, and it had a great response. Do you remember that we were selecting the abstracts? And then another thing that we talked about is that it had to be with academia and activists. And this is also a very, groundbreaking thing from the book. The book is not only written, or the essays are not only written by scholars, which also are not traditional scholars. Like many people in the book have always been with the double hat between activism and scholarship. I feel myself, I am like a unicorn, like a hybrid person that is always trying to trespass, because I don't really feel comfortable as Dean Celorio, I am sure, in sitting in my desk writing. I need people, I need cost lawyering. So cost lawyering is something that deploys you to the streets, to the cases, to litigation. So this book is a conversation, it's an international conversation between scholars and activists that have been near us, but also new voices. We have young scholars and young activists coming into this conversation. And I am very proud of it, because we did it.
I actually think, one of my favorite parts of it is that it's a combination of voices,
Right.
And I think we need that, in academia. We do need a space, that combines, those, scholarship and academic perspectives, but also with what's happening on the ground. A lot of the problems, are massive to a point that you do need the combination and articulation between academia and practice, And connected to that, I have a question for you about the topics covered, right? Because there's 4 angles, right? We have, it's a collection of essays, right? Many of them touch on intersectional discrimination, which have essays. We also have essays that touch on violence against women and LGBTIQ plus persons, sexual and reproductive rights, but also challenges to protect human rights in situations of armed conflict and crisis. Why those topics? Because they're certainly not the only ones, that we discuss in women's rights issues, and gender issues. Why those particularly?
That's a very good question. I think this reflects also the topics that people want to have a reflection on. Like, for example, the intersectional discrimination conversation, it's a really, hot topic of the moment. Like, everyone wants to do intersectionality. The question is, how do you do that? Is it a theory? Is it a methodology? Is it a tool for analysis? So what exactly does intersectionality means? And how is it being used besides the tropo, right? Like the logo. I feel that Monica Arango and Oscar Parra and Dean Celorio herself, which she has this extraordinary recent publication on autonomy and intersectionality, and you should read that paper, homework, right, if you haven't read it. Yeah, we are.
It's kind of long, though.
Yeah, we are teachers. We do assignments. So there is an important not like Crenshaw did this fabulous thing of naming, right, intersectionality, and we are discussing now how to apply it. How to, and I will say briefly what I think intersectionality is not. So intersectionality is not an accumulation of vulnerabilities and discrimination. So you don't, you don't put a sum sign, no? Race plus gender plus class. It's a theory, or it's a reflection on crossroads, on how are we having what we know in feminist theory as a situated experience. When you have a situated experience, it comes, you have a de facto situation, because I think that intersectionality applies better, and this is why, or how its origins begin, with an analysis of constitutional law and anti-discrimination clauses, right, applied in cases. So this is not actually, I feel, a theory or a methodology to do public policy, because it's a theory, or it's an idea that it's very casuistic. So you have a situated experience of discrimination regarding a person, mostly, because I have a question on how you can develop patterns, because that's an empirical question, right? So you have to analyze first the situated experience of this person. What happened to her, him, or however the identity of this person is. But it's not about multiple identities. It's a multidimensional experience of on axis of oppression, but it's not saying to the judges, there are multiple identities there that you have to combine. So it's not an easy thing to exercise outside a courtroom, because you need a case to analyze it with this intersectional lens. But it's not, a theory of identity. Identity is a very complex issue that intersectionality brings a tool to give a lens, give a dimension on how this person is situated in a political space, in a historical background, with a series of conditions and characteristics that makes her or his or it experience a certain, mosaic of different axes of discrimination. It's not that we are, because if not, you can you can think about it as a fragmented idea of identity, which is not, or an essentialist approach to identity, which is not, or a cumulative idea of how we think of difficult issues that we cannot name otherwise. So I think this book explores how the Inter-American Court is dealing with that. I feel the court has to do a more, and Monica and Oscar, I really, their essays are very good in that, and Rosa herself, are saying, we should think about this in a context. We should think about this in how people are experiencing, given X conditions, discrimination, and having to craft remedies that are transformative of these conditions, which makes sense, right? But it's not a theory of identity. Then violence against women, which has been, a very difficult issue to, it is the same thing, Sometimes topics are communicated as in a very political correct way. So now I'm very preoccupied, and maybe you share my preoccupation, that which is not the angle of the book, by the way, that the women's rights movement is naming institutional violence, structural violence. So I'm telling my students, but what is that? So what is institutional violence? What is this concept? So if everything becomes violence, then we are deprioritizing or diminishing a very serious human rights violation. So the book, in this sense, makes several contributions. There is a very good article, and I don't know if Rebecca Reingold came today. Hopefully, they are there. Oh, thank you for coming. Thank you for coming. Some of the authors are here. So, first of all, their excellent essay on obstetric violence, right, which is a very recent, or we are naming obstetric violence as a form of reproductive violence. And they are saying a very important thing, that is, we should frame this issue as a human rights violation and not as a crime, right? It's a very good argument. I am not going to do spoilers on this essay, but they are giving strong feminist arguments on why criminalizing this kind of conduct in medical settings, it's not a very good idea, right? So the book is making contributions as to why using human rights language, why using a human rights instruments is still a better idea than coming to criminal law. And I'm sorry if there are here criminal lawyers. It's not that it's against you, no, but the thing is, we are facing what is called a criminal populism in Latin America, where the most easy way for politicians to deal with grave situations is criminalizing stuff, right? So this book has also an angle, a critical angle. So as I tell my students, before you say, let's criminalize something, let's reflect on that hypothesis, or on that, because criminalization is a public policy. So, and it's the strongest public policy. Is the worst way a government can deal with a very complex situation or a health issue, right? Why should health issues be a crime? that's also a question for abortion, right? Why should health issues be a crime? So this book argues in a relation, or highlights a relation that Dean Celorio has contributed a lot when she was in the rapporteurship of the Inter-American Commission on Women's Rights, on how violence against women is related to discrimination and inequality. So this is a relation we should explore more, conceptually, practically. What is the link between someone that is beaten and the idea of his or her inferiority, right? Because it's not the same, violence and discrimination. Violence is a mistreatment that gives you a harm, or that provides a harm, a different type of harm, no? Psychological, economic, moral, whatever type of harm. It has to do with the theory of harms and how we can, repair harms that are not material. That's another question. And discrimination is an unjustified treatment, and an unjustified. So it's not that it's wrong to differentiate. It's wrong to differentiate if you don't have a good reason to do so. So equality is a question that always brings you to a comparison, right? So different to whom, different to what, in terms of what are you thinking that you can treat this person in a different way. So for me, violence and discrimination are, of course, as the committees say, the UN committees, are related issues, but they are not the same. They have different or sometimes related causes. This is also an empirical question, right? Why violence appears repeatedly in X setting? It's a question that can only be answered going to the setting, interviewing people, XXX. And the idea of equality or the idea of inequality is an abstract thinking on how can you not erase difference, but treat difference in a way that people do not get disadvantaged in their rights. So the book deals with these questions all along. In another chapter, there is a reflection on the armed conflict in Colombia and how sexual violence has been there used, as the feminist movement will say, as a weapon of war, right? Which is a feminist radical discourse in the idea of radical understood here as a dominance, as a paradigm of sexual dominance, right? This is what radical feminist is, that you believe that you are dominated by sex. So these essays delve into these important questions on how do we think about sexual violence in war, or how do we think about the different countries that have a very precarious criminal and justice system. And so I feel that the book is also about those hard questions. How do we look at problematics that are common problematics in Latin America or even beyond Latin America, right? Because the other essay that is of Mary Ellsberg and Chelsea, it's a very good study on 6 countries, and I have it here, which are beyond Latin America. And this is very interesting, no? Because this is an essay that compares 6 countries that have different settings and backgrounds, and gets the conclusion that they are the same in a way, that they have failed women that are survivors of violence. So we have a clue there, right? If so many different countries fail women the same, what can we do better, right? And this is an important empirical question. So I don't know if I answered in a way or
I
not.
think you did. I think we all want to take your class now.
No.
Yes. And I actually have one final question for you,
Okay.
because I want to make sure our audience has a chance to ask you questions. You know, we basically say that the book has a feminist, queer, or gendered, and human rights perspective. Right? Why is this critical for women's rights, today and international law? Why is that important?
Yeah, I know. This is a question about our perspectives, right? And so, and this is a good example of this problem that is beyond linguistics, right? It's the transgender movement now fighting for the rights. And when we say that the book has all these different approaches, it's because I do believe that beyond the naming, we should be inclusive of perspectives. I feel perspectives need to have a conversation, and this is a conversation that involves different movements. So when we say that there are critical perspectives of queer persons, it's because there are people that are queer writing in the book, and that have come from the LGBT movement, the transgender rights movement. So it's because people that are situated in this personal experience are writing the essays. So this is another contribution of the book. When we say that there is a feminist perspective, it's because there are feminist scholars writing in the book. When we say, that there is a gender perspective to the book, it's that because we are trying to dialogue on what is that? What is a gender perspective in human rights? So these are the movements that are trying to dialogue in this book that have different perspectives, that are saying, when we, for example, Lisa Davis, that when she was part of the drafting the Crime Against Humanity's Treaty, why doesn't the gender perspective is useful in this treaty? Because if you understand by gender perspective the binary, the sexual binary, then I think we go back to the 80s. And I love the 80s. They are great in music, Freddie Mercury, very great. But we are coming back to these debates of this, I'm saying it in a way, this vintage, not to sound old, debates on feminism, or on the divide of sex and gender, and if is sex biological or is gender cultural, right? This was the question of the 80s. And now that the transgender people are fighting for their rights, we are coming back. We are revisiting this question of, is sex biological and gender cultural? And so I feel, that if this is what people want to have a dialogue on, because I thought, honestly, that we had been beyond that. But then you read, the dissent opinion on the Vicky Hernandez versus Honduras case, and you see that not everyone has passed this debate on the sex and gender binarism. Some people think, that the Convention Belém do Pará, because it's framed in women's rights terms, it's a treaty that should not be applied to trans women. So there is the binary, and this is a radical feminist writing the vote. So you also have to read the perspective. Read the perspective of who is writing this vote, right? So this is why we have different perspectives in the book, because people write from different places, and we don't want to exclude anyone, but have I always feel that these conversations need to happen. We need to have a dialogue, and this is why this book is alive.
Yes. And I want to thank you so much for sharing your wisdom, your insight, but also kind of explaining in many ways why we're still having dialogue on these issues, why there are so many lingering questions. You know, when we talk about women's rights today, it's not easy. Not everything is resolved. This is an evolving area of the law, and every day it is important that not only we push the boundary, but we give space for different voices, different perspectives, you know, and try to reconcile, resolve issues, at least find consensus on some issues, but it's not easy to do from what we are seeing. And I think when you look at our publication, you kind of get a sense, you know, of how complicated this is, how challenging it is, but I think we're posing the questions. And I thank the authors for that, you know, especially because they work with us for a long time, you know, and thank you, Alma, so much for your leadership. It was an honor working with you on this publication, you know, and I do hope that when you review it, you enjoy reviewing it as much as we enjoyed preparing it, okay? And remember, these are not easy issues, you know? So thank you for clarifying that for us today. And I want to open the floor for questions because I know some of you have class at 2 o'clock, so I just want to make sure at 3 o'clock. So please.
Thank you very much. It is amazing to have you both and listening to you both while I was just signing the papers of my book. I wanted to ask so many questions, but I have to just codify them in one sentence. I just want to first say my perspective about this area of law and my general point of view in the world is that I can't be identified as a humanist. I am a feminist, although I may not fit in the classical feminazi view that people want to label us as. But because I think for humanism to survive, feminism should survive first because we give birth to the mankind. We have a very famous Turkish poet saying this word. He's a man, that's a man talking. He says, we are not human. We are the sons of the humans, and those humans are the women. So this is where the women should be treated as, because I think in most of the conflicts, they are the first victims to be targeted at, so they need special care in all aspects of law. And so I came up with one question while listening to you carefully. Given the persistent disparities in the enforcement of international women's rights law, unfortunately, how can feminist legal theory be more effectively integrated into the international legal framework so we can address both the state accountability and intersectional discrimination, and particularly in regions where cultural relativism is often invoked to justify violations? Thank you very much.
How can what? I missed the how
Feminist legal theory, how it can be incorporated into
feminist
legal theory in basically current international legal regimes, right? You know, when it comes to enforcement.
Another question? We can take several.
Oh, yes. Other questions, and we'll answer yours as well. Yes, Joaquin.
Hi, thank you very much, Professor Alma. I was interested in the last part of your speech when you talk about the gender and sex, because I come from Spain, and 2 years ago we passed a law that recognized the right to the self-determination of sex, and someone could be decide if it's a man or woman. It has arisen a strong debate in the country, and we have started to see the consequences when men use or take advantage of this law unlawful, or to take some advantages that we have protecting women. I would like to ask you about your opinion about this kind of laws, and what do you think that we can face, or how we can face these kind of situations?
These are great questions. We can take at least one more. Yes. You want to stand up?
Oh, sure.
Thank you.
Really appreciated this talk, and I I was wondering if you could touch more on maybe how intersectionality as a lens rather than a methodology can still is interconnected with this inclusiveness that is used in this book to include queer folks as well as feminine and feminist ideas.
Thank you. Well, I love these questions. They are so fun. Well, the feminist legal theory question. Well, I am. We could have. I teach a whole seminar on feminist legal theory and the interventions of feminism in international law. But you can see basically two main theories running in international law discourses, and these are the radical feminists like McKinnon, and which have had a really important intervention in human rights law and international law, saying basically this: no, violence against women is an experience all women share, and international law should take it seriously, and this is binded to an idea of sex equality, right? So this is the dominance paradigm, and you can see how it, sexual violence as a crime of war. Sexual violence is it's a prevalent issue in this feminist legal theory, and the idea and how to change the paradigm is empowerment and feminist jurisprudence. So one topic. And then the other side that I feel it's also a prevalent in international law is the liberal part of feminism, right? It's autonomy, it's agency, it's saying, for example, sexual work is work, right? It's not domination of your body, but a woman or a queer person able to express himself, herself, and deliver sexual desire to society, paid, but it's enjoyable. It's part of agency. It's part of what we should acknowledge as work, and international law should protect it as labor. So the first thing I would say is that you have to recognize which feminist are you, right? Because it's not the same if you come from a radical view, or if you come from a liberal view, or if you come from a cultural view, right? For example, domestic work. Domestic work, cultural feminism will say it's a thing that women do, that the state should take a real interest, and women do it better because they have done it always, and it's in our culture, and it's tied to reproductive decisions, and it's right. So it's not the same. The question of enforcement has to do with the question of theory, because if you clarify your theoretical standpoint, then you can clarify your practical strategy. It's not the same where you present an issue, how you argue it. Then you will get to a different solution, because these theories do not combine also. Being a liberal radical, it's difficult, at least theoretically, right? So you have to first acknowledge where you come from to see where you go to. On the second question of self-determination and sex laws or sexual laws, transgender laws, I feel the real question is, how can law accompany better people that are doing a transition? Transsexuality, transgender, trans whatever means to do a transition. from point A to point B or to wherever the journey takes that person. So the question is, how can we as lawyers accompany those processes? And I suggest to do it, I feel this is the typical area where law should bring other experts to the conversation, but not to over-regulate. Not to go and tell people, then you should go to the psychiatrist, then you should, No. To get a better grasp of what is needed in the legal area so that we can do a better regulation. And some people will try to take advantage, probably yes, but that's not the people who the laws are for. The laws are for people who are in a situation of transition, that are having a very difficult problem with adapting their body to their desires, to their performance, to what they want to be. Imagine a world where you are shaping yourself. Now, we are always shaping ourselves. This is not a question. The issue of transgender rights, it's very, very sensitive because it deals with a person's autonomy and agency, to decide what she or her or it or they want to become. And that's a very difficult matter. Some people, we feel right where we are in this vessel of skin and atoms and blood and whatever. Some people don't. And we have to respect that decision and accompany the decision. So we make laws for people who are in trouble, not for people who want to cause trouble. You see the difference? So, the third thing, intersectionality and the queer theory. Well, again, I feel intersectionality is not the response for everything. I feel intersectionality is a way of looking at cases with a better lens, trying, to develop a better methodology in analyzing axis of oppressive discrimination that we have always been subjected to, right? Race, class, sexual orientation, which can be also a form of oppression, but not sexual orientation, heteronormativity, right? Like the idea that everyone has to be heterosexual. That is the oppression of sexual orientation, right? The idea that you have to be that you want that you have to get in bed with someone from the opposite sex. That's heteronormativity. So I feel it depends on the case, right? Because the queer theory, I like how they have come with this idea of the queering, right? Queering, making something queer. Imagine I'm thinking of doing an event now in a conference that I am organizing with many people, etc., the ones that we like. And the art performance is going to be drag folklore. Drag. So I don't know what this is, but this is queering, right? To put drag in folklore, in a popular dance. Imagine what that is. So the queer theory in law is like that, putting drag in the folklore, like dragging law, like putting, some twist that has to do with extraordinary turn point, And this is not an easy thing for law, because law wants to make rigid categories, wants to tell people you are female, you are male, or what are you. We want to name. So think a queer perspective, it's a detonation on naming, on essentializing, on imagining something extraordinary can happen if you relinquish your idea of naming before exploring. So queer theory, it's a different approximation, a different approach, and it doesn't necessarily has to do with intersectionality, right? As a sexual orientation grounds case for discrimination, or a thing you have to take into account in a case.
No, and I wanted to add, aside from what Professor Beltrán y Puga explained very eloquently, two things. When we think today about women's rights issues, when we think today about LGBTIQ plus issues, remember that a lot of this, at least in the development of international law, we're grounding it on human rights. And a lot of human rights development happened after World War II. And this entire regime that was developed in World War II was really meant for the public sector, for public spaces. It really wasn't a regime made, for zones of intimacy, for identity, for autonomy, for agency. This has come much later, right? And I like a lot what you just said about how we're really still in a process of, making this, more reflective of current needs, of current needs that women have, of current needs, that trans persons have, Remember, this is supposed to be about human beings. And what that means is also about their authenticity, about their identity, about their transitions, about their experiences, and about respecting rights within those processes, right? We have become much better in international law at reflecting women's needs, but we're not perfect. We're far from being perfect, of course. And now, especially in the last 15 years, we have started that process with LGBTIQ plus groups, And I like a lot what Professor Beltrán Puga said, that this is not just about, granting rights, in a void context. We're talking about making sure human beings have dignity, in the decisions that they make related to their authentic selves, right? And this is why in women's rights, even though this can be very controversial, especially when you think of the definition of women, we are granting that space. And we are saying, it is important that trans persons are part of the dialogue, especially because this is part of their authentic selves, right? And this is where the autonomy and agency comes in. But the other aspect, and this really goes to Taylor's question, is that when we talk today about intersectionality, we're also talking about participation. Part of the problem is that a lot of the groups most affected by discrimination are groups that have had really very little involvement with the development of international law today, as we know it. Even CEDAW, even the major treaties that we have, the Convention of Belém do Pará, these violence against women conventions that we have at the regional level, a lot of groups of women themselves haven't been a part of them, like indigenous women, women of African descent, and other groups of women as well, right? So there's a long way to go in terms of not only, implementing current standards, but also how to carve standards that really come from the bottom up, that really reflect, that participation and that inclusion, right? And it's not easy to do. When you talk to a state about intersectionality, it's very difficult to explain what that means in practice, right? How do you reflect that in legislation? How do you reflect that in a policy? How do you reflect that in a program? However, a state does understand when you say you should have a space, for indigenous women to participate and have a voice and have a real incidence, or, trans women, you know what I mean? Or women that are bisexual, or women that come from other communities that we know they're very historically discriminated against, right? That is a step. But we're still trying to figure out what this means, But I do think Professor Crenshaw did an incredible contribution naming something that was there and really we weren't aware of it, right? And I do like a lot what Professor Beltran Puga said about intersectionality is not plus, 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 right? It's really more a fuller understanding of a person's discrimination experience. And this is very connected to dignity, And if there's something, that you take from this talk today is about the fact that all human beings, whether you're a man or a woman, really should have their dignity respected. The reason why we're having these conversations is because women have been at the top, of communities and persons and groups and individuals that their dignity has been historically and in the present constantly disrespected. And we're trying to restore that. We're trying to advance a number of values so that women can really act with autonomy and agency and self-determination and be their authentic selves, however we define women. Thank you, Professor Beltran Puga, for really teaching us a great deal about this today, about a very complex area of international law. I'm so proud, that you are here in a women's rights event. You never know what's going to happen in a women's rights event. Sometimes you have a lot of people. Sometimes people are like, I don't know, that might be a little bit too controversial. But I do have a lot of pride that GW Law hosts difficult conversations, about challenging issues. This is a challenging one. So thank you again for helping us through this conversation. Thank you to the organizers again of this event. And thank you so much for the authors of this publication. We are so honored that you lend your time, your wisdom, and your insight, to a very important dialogue. Okay? Have a good rest of the day.
Thank you so much.